impeachment of a person in law is by way of cross-examination. When a person has not presented themselves for cross-examination, it becomes very difficult to test that particular evidence. However, the Speaker may seek solace in the fact that even though Sakaja has not presented himself for cross-examination, the Senate will see the probative value to attach to Sakaja's statement. By probative value, we mean how serious will the Senate treat the evidence by Sakaja. And the problem is you cannot know in the minds of the senators how they took that statement. If it was in a court of law, reasons would be given that this affidavit was not given any weight. But by admitting the affidavit, the Speaker is generally telling senators, you can rely on the contents of this affidavit. It is up to you, it is up to your conscience to make out of it what you think is true, what you think is not true, so that it guides you at the time of voting.
A lot of legal issues have come up in the course of this hearing, including whether a state officer, and this time the governor of Siaya County, that is James Orengo, should even be party to those proceedings. Do you expect that these issues will come up in court for adjudication?
It will come out in court because it has been an issue in court. Remember, Orengo represented Peter Ojamong in Busia during the 2017 election petition. And it came up that as a senator, Orengo was conflicted. But the judge then ruled that as a senator, Orengo was not a public officer in its strict sense, was allowed to continue. In the case of Philomena Mbete Mwilu versus the Republic, again it was brought up. But the court ruled in favor of Orengo, saying senators do not hold a similar position as public officers serving the executive. But yesterday, Orengo was appearing in Senate as a governor. He is governor for Siaya. He is no longer senator. So the court again will have to determine whether by being a governor and appearing in court as counsel for the National Assembly, Orengo broke any law and was conflicted. That will generally and technically come up as an issue for determination in court when Gachagua again moves to court.
So do you expect this to be a precedent-setting events in terms of jurisprudence?
Obviously, jurisprudentially, it is going to be a high-end case. It is a case that is going to enrich our jurisprudence, enrich our laws, not just in Kenya, but in the entire common law. Remember that even as advocates, we are unable to get references with ease where this has happened before and we can borrow from. And therefore, right from behind, this is a matter that will go all the way to the Supreme Court. And by going all the way to the Supreme Court, it will help in the development of the law. So that another day, if we choose to impeach a president or a deputy president, we have well-settled principles courtesy of the Gachagua case.
All right. Thank you very much for speaking to us. Wakili, that is Advocate Ken Chesa, responding to the events that have just transpired at the Senate, which has been seized with the impeachment motion for the removal of the Deputy President. Deputy President Rigathi Gachagua, who was expected to testify this afternoon and begin his defense, did not show up. The information from his counsel is that he has been taken ill and has been hospitalized. Paul Mwite, who is his senior counsel, then asked for time up to 5 p.m. for him to ascertain what the status of his client is and therefore for him to give direction, or rather make a case for what direction should be taken moving forward. The Speaker of the Senate, Amason Kingi, then took submissions from the majority and minority sides of the Senate and thereafter resolved that they have until 5 p.m. So the session in the Senate has been adjourned until 5 p.m. when it is expected that the Deputy President, Rigathi Gachagua, will be examined by his counsel and give his defense and thereafter be cross-examined by the legal counsel of the National Assembly. And as you heard there from Chesa, this is an unprecedented situation. Of course, the impeachment process against a deputy president is historic. It has never before happened under the current constitutional dispensation. And a person who is on the defense not turning up to give a defense is unprecedented as well. We are joined now by Dr. Eric Komolo, an advocate of the High Court of Kenya. Karibu sana.
Thank you very much.
Wakili, did you anticipate what we're witnessing now?
Not at all. You can even see everyone is a bit shocked what has happened. We didn't expect that he will not appear. He didn't look, for those of us who have been watching, he didn't look unwell. But things do happen.
Senator Sigei, please take your seat. Now, honorable senators, we are facing a very unprecedented situation. At the rise of this House at 1:15, I indicated that upon resumption, we were going to hear the Deputy President. Upon resumption, Senior Counsel Paul Mwite, for and on behalf of the Deputy President, when I asked him to usher in the Deputy President for purposes of presenting him to give his evidence in chief, the Senior Counsel indicated that even him, he was unaware of the whereabouts of his client, and he asked for a few minutes to go fetch him, wherever he was. After a few minutes, Senior Counsel Paul Mwite came back to the chamber and indicated that he had gotten information which he was yet to verify, that his client had fallen sick, and indicated that he needed time to go look for him in whichever hospital he is, and that he should be given up to 5 p.m. today. The Counsel for the National Assembly, in response, indicated that this is a time-bound process. He referred to the Senate